I came home from the hospital the same afternoon my husband was buried, still wearing the black dress I had not changed out of in 3 days, and the first thing I heard when I pushed open the front door was my mother-in-law laughing. Not the quiet, polite kind of laugh people do to break the silence at funerals, a real laugh, the kind that comes from the belly when something is genuinely funny. I stood in the entryway of my own house, my hand still on the doorknob, rain dripping from the hem of my dress onto the hardwood floor. And I just listened. My name is Tatum. I am 31 years old, and 3 days before that moment, my husband Conrad had died of a brain aneurysm while sitting at his desk at work. He was 34. He had kissed me goodbye that morning, told me I smelled like coffee and sunshine, and walked out the front door. He never came back. What I am about to tell you is not a story I share for sympathy. I share it because I know some of you are living inside a version of it right now, and you need to know that the people who bet against you can lose everything. Before I tell you what I heard through that door, let me go back 24 hours. I had spent the morning of the funeral at a private meeting with Conrad's estate attorney, a quiet, precise woman named Ms. Hargrove, who spoke in a calm, measured voice that I found oddly comforting. Conrad and I had been married for 4 years. I knew he worked in private equity. I knew he was careful with money. I knew he drove a 10-year-old car even though he could have bought something better. What I did not know, what he had quietly, methodically built without ever making it about himself, was that Conrad had accumulated just under $9 million in a diversified private trust, along with a 40% ownership stake in a regional logistics company headquartered in Nashville that his firm had helped take from near bankruptcy to profitability over 6 years. The company was now worth roughly $62 million. His stake, my stake now, was worth close to $25 million. I sat in Ms. Hargrove's leather chair and stared at the numbers on the document until they stopped making sense and then started making sense again. Conrad never told me because he never wanted money to be the reason I stayed. He said that once, early in our relationship, as a joke. I did not realize until that afternoon that he had meant it seriously enough to build an entire financial architecture around it. I left her office holding a sealed portfolio binder and went straight to the cemetery. I cried at the graveside in the way that makes your whole chest hurt, the kind of grief that feels like something is physically wrong with your body. My mother-in-law stood across from me, in a charcoal coat, dabbing her eyes with a tissue. My father-in-law stood beside her with his jaw set in that way men do when they are trying to look composed. Conrad's older brother stood slightly apart from everyone, checking his phone twice when he thought no one was watching. I drove home alone. And then I heard the laughing. I did not move. I set my bag down softly on the entryway table and stood perfectly still in the dark hallway, the way you do when you realize that moving will give you away. My mother-in-law's voice carried clearly from the living room. She was saying that Conrad had always been soft, that he let sentiment drive his decisions, that a man with real business sense would have had everything properly structured so that the family could access assets without dealing with the complication of a widow who had only been in the picture for 4 years. She used the phrase only 4 years like it was a diagnosis. My father-in-law grunted in agreement. I recognized the sound. It was the same grunt he used to signal that the conversation was now beneath further discussion, that a decision had been made. Conrad's older brother, whose name is Barrett, spoke next. His voice had that particular edge it always got when he was performing competence he did not feel. Barrett is a real estate developer who has been on the edge of a major project for as long as I have known him, always one deal away from the thing that was going to change everything. He said he had already spoken to an attorney, and that there were grounds to challenge the trust distribution on the basis that Conrad's mental state in the months before his death could be called into question. He said it the way people say things they practiced in the mirror. He said the word incapacitated, like he had looked it up specifically for this conversation. My mother-in-law said that if I were a reasonable woman, I would simply agree to let the family manage the estate through a joint executor arrangement. She said I was young and inexperienced and that grieving widows made poor financial decisions and that the family had Conrad's legacy to protect, and surely I could see that it was in everyone's best interest for people with more experience to be involved. My father-in-law said I was emotional. Barrett said he had a draft of a document his attorney had prepared that would establish a temporary co-executor arrangement. He said he would present it to me tonight, while things were fresh, while I was still in a vulnerable state. He used the word vulnerable, the way a predator uses it, as a descriptor of opportunity rather than an expression of concern. I am a licensed CPA. I have worked in forensic accounting for 6 years. Before Conrad and I got together, I had already spent 3 years auditing estate fraud cases for a litigation support firm. I have sat across from some of the most sophisticated financial manipulators in the country and watched them lie under oath. My grief was real. It was enormous. It was the kind that sits on your sternum and makes breathing feel optional. But underneath it, my brain was already running. Conrad and I had talked about this. Not this specific scenario, not his family specifically, because we had no reason to believe it would come to this, but we had talked about protecting assets from bad actors. We had talked about it in the abstract, the way two people who both work adjacent to financial crime talk about it over dinner, as a kind of professional habit. 3 years into our marriage, after I had worked a particularly ugly estate fraud case involving a young widow and her late husband's siblings, Conrad and I had sat down with Ms. Hargrove and added a specific provision to his trust documents. The provision was a clause that flagged any attempt to establish a co-executor or third-party management arrangement without my explicit, verified consent given in person at Ms. Hargrove's office with 24 hours advance notice. Any document signed outside that protocol was automatically void. Ms. Hargrove had a copy. The Federal Trust Registry had a copy. Conrad had called it the seatbelt clause. He had laughed a little when he named it. Standing in that hallway, I thought about that laugh and pressed my hand flat against the wall to keep myself steady. Then I took a breath, smoothed the front of my dress and walked into the living room. The effect was instantaneous. The laughter stopped. My mother-in-law's face rearranged itself into grief so quickly it was almost impressive. She opened her arms and pulled me into a hug that smelled like her expensive perfume and felt like being held by a department store mannequin. My father-in-law stood and put a hand briefly on my shoulder. Barrett crossed the room and said he was so sorry. He looked at me with the specific expression of a man who is calculating something. I let them steer me to the couch. I let them bring me tea. I did not drink. I let my mother-in-law stroke my hand and say that Conrad would have wanted the family to come together in a time like this. I nodded at the right moments. I let my eyes fill up, which was not difficult because the grief was real and available at all times. I just let a little of it show on the surface while the rest of me stayed very quiet and very still. Like still water. Barrett sat down across from me about 40 minutes later. He had the document in a manila folder. He set it on the coffee table between us with a kind of practiced casualness, and then explained it in the same tone someone uses when they are summarizing terms and conditions and hoping you will not read them. He said it was a temporary arrangement. He said it was just to make sure the estate was properly managed during the transition period. He said I would still be involved, of course, as the primary beneficiary, but that an experienced co-executor would take the lead on the more complex decisions. He slid the folder across the table. He held out a pen. I looked at the document. I could see within 30 seconds that the co-executor named was not a neutral professional. It was a shell company registered in Delaware, and Barrett's name was buried in the second paragraph as the managing director. I looked up at him. I picked up the pen. I signed every page, but I did not sign my actual signature. Conrad and I had one more layer that Barrett did not know about. Years ago, after a glass of wine and a conversation about a particularly elegant fraud scheme I had been studying for a case, Conrad had suggested we each create a documented alternate signature, not a forgery, an officially registered variant, logged with Miss Peckney, Hargrove, and with our bank, flagged as a distress signal. If either of us ever signed with that specific variation, a leftward lean on the capital T and a doubled loop on the final letter, it triggered an automatic hold on any document presented for processing and sent an alert directly to Ms. Presented, Hargrove's encrypted monitoring system. Conrad had called it the escape hatch. I signed every page with the escape hatch signature, slowly, with a slightly trembling hand, and let one tear fall onto the paper for effect. Barrett took the folder back before the ink was fully dry. He did not hide his relief well. My mother-in-law squeezed my hand and told me I was doing the brave thing. My father-in-law nodded in a way that meant the meeting was adjourned. They stayed another hour, and then they left. I stood at the window and watched Barrett put the folder into the back seat of his car like it was a treasure he had not expected to get. My mother-in-law walked to their SUV without once looking back at the house. I locked the front door. I sat down on the kitchen floor because I needed to be on the floor for a moment. And then I picked up my phone and called Miss Hargrove. She answered on the second ring. I told her the escape hatch had been triggered. I told her the document Barrett had presented, the shell company, the Delaware registration, all of it. She was quiet for exactly 4 seconds, and then she said, "Understood," and I could hear her already moving, already working. She told me she would have a full asset lock on the trust by morning and that any attempt to process the document Barrett had in his back seat would be stopped and flagged at the federal level. She told me to get some sleep if I could. I did not sleep. I sat at the kitchen table with my laptop and started pulling public records. It took me about 2 hours to find the shape of what Barrett had actually been building. He had 3 active real estate development projects, all of them in various stages of distress. 2 had liens filed against them. 1 had a pending lawsuit from a general contractor who claimed Barrett had bounced a payment of nearly $400,000. Barrett's company was carrying debt that would require a significant cash injection to stabilize. He had applied for a loan 6 months ago and been turned down. He had applied again 3 months ago and been turned down again. He needed money. He needed it soon. And Conrad's estate was the cleanest, fastest access point he could see. I saved every document into a secured folder and sent the package to Ms. Hargrove before 3 in the morning. The next morning, Barrett called me at 9. He said the bank had flagged the document for additional review. He said it was routine for estate-related transactions and that his attorney was handling it. His voice was controlled, but the edges had a brittleness to them. I told him I was sure everything would work out. He paused for a moment longer than comfortable, and then said he was sure too. That afternoon, my mother-in-law arrived at my door unannounced. She had brought a casserole which she set on the kitchen counter, and then she sat down and told me that the family was concerned about me. She said I seemed to be holding up unusually well for someone who had just lost her husband, and that this was sometimes a sign of delayed shock, and that it might be good for me to have someone assist with my day-to-day affairs. She said the word affairs with a particular emphasis. She said she and my father-in-law were prepared to step in, informally, to help me manage things while I was processing. She said she had always thought of me as a daughter. She had not thought of me as a daughter for 4 years. She had thought of me as the woman her son had married, who was not from the right background, who did not have the right connections, who was pleasant enough but not quite what she had imagined for Conrad. I had watched her think this across 100 dinners and holiday gatherings and birthday parties, where she smiled at me with warmth that never quite reached her eyes. I told her I appreciated her concern and that I was managing. She pushed a little harder. She said the family only wanted what was best for Conrad's legacy. She said that a young woman alone was vulnerable to bad advice. She used the word vulnerable again, just like Barrett had, and I realized they had probably talked on the phone that morning and aligned on vocabulary. I told her I had excellent professional support and that I was in good hands. She left the casserole and drove away, looking unsatisfied. 3 days later, Barrett came to my house in the evening with his attorney. The attorney was a small, sweating man in a suit that was slightly too large for him, and he carried a briefcase that he held against his chest like a shield. Barrett had not called ahead. He knocked hard enough that it sounded urgent. I let them in. Barrett's attorney produced a document he called a notice of estate claim. He said that Conrad had borrowed $250,000 from Barrett's company 18 months ago as a bridge loan, and that this constituted a debt against the estate that needed to be settled before any distribution to beneficiaries. He slid the document across my kitchen table. I looked at it. The formatting was wrong in 3 places. The interest calculation was based on a rate that violated Tennessee state lending law. Conrad's signature at the bottom had been traced badly from what looked like a scan of one of our joint documents. I recognized the particular curve of the letters because I had watched Conrad sign his name hundreds of times. I looked up at Barrett. I said, $250,000. He said yes, and that he was sorry to bring this up at such a difficult time, but that the debt was legitimate and the estate was responsible for it. I said I did not recall Conrad mentioning it. Barrett said Conrad had not wanted to worry me. He said Conrad had come to him quietly because he was too proud to admit he needed help. He said it with practiced sadness. I said I understood. I said I would need a few days to review it with my attorney. Barrett said that unfortunately the claim had a filing deadline, and that he needed me to acknowledge the debt in writing that evening, or his attorney would have no choice but to file a formal estate claim with the probate court, which would freeze all distributions until the matter was resolved. He pushed a single sheet of paper across the table, an acknowledgement form, a pen beside it. I picked up the pen. I turned on the recording function on my phone, which was sitting face down on the table. I had turned it on when I let them in. I looked at Barrett and I said, "Just so I understand correctly, you are telling me that Conrad borrowed $250,000 from you personally, and that you want me to sign an acknowledgement of this debt tonight, and that if I don't, you will file with the probate court in a way that will freeze the estate?" Barrett said yes, that was correct. His attorney shifted in his chair. I said, "And the interest rate on this loan is the figure listed in this document?" Barrett said yes. I said, "Are you aware that this rate exceeds the maximum allowable under Tennessee's consumer lending statute?" The attorney said this was not a consumer loan and a different framework applied. I said I would make a note of that. Barrett reached over and tapped the paper. He said we were running out of time and he needed an answer. I set the pen down. I told Barrett that I was not going to sign anything that evening. I told him the signature on that loan document was not Conrad's. I told him I was a forensic accountant with 6 years of experience identifying document fraud, and that what he had placed on my kitchen table was a fabricated instrument, and that presenting it to me as a legitimate debt claim while attempting to pressure me into signing an acknowledgement was textbook estate fraud. Barrett went very still. His attorney began putting papers back into his briefcase. I told Barrett that our conversation from the moment he arrived had been recorded, that I would be forwarding the recording along with the loan document to Ms. Dead Hargrove and to the Tennessee Bureau of Investigation's Financial Crimes Unit, and that I was asking them both to leave my home immediately. Barrett stood up so fast his chair scraped back across the tile. He pointed at me and started talking about lawyers and defamation and family loyalty and what Conrad would have thought of this. I walked to the front door and opened it. I said, "Good night." They left. I sat down at the kitchen table and let myself shake for about 5 minutes. Not from fear, from the particular physical release that comes after you have held yourself together under pressure for an extended period. Then I stopped shaking, picked up my phone, and sent the recording to Miss Hargrove. What happened over the following weeks was not dramatic in the way that television makes things dramatic. It was methodical. It was paperwork and phone calls and timestamps and legal filings, but the effect was total. Ms. Hargrove filed a formal fraud report with the estate court. The recording I provided became the centerpiece of an investigation that expanded quickly once investigators began pulling Barrett's financial records. The forged loan document was analyzed and confirmed as fraudulent within 10 days. Barrett's shell company, the one named as co-executor in the document he had presented the night of the funeral, was found to be part of a pattern of fraudulent debt claims he had filed against 2 other estates in the previous 3 years. Both of those cases had been settled quietly because the surviving family members had not had the resources or the knowledge to fight back. I did. My mother-in-law called me twice during the investigation. The first time she told me I was destroying the family and that Conrad would be ashamed. I listened and then said goodbye and ended the call. The second time she was crying and told me that she had not known the full extent of what Barrett was doing, that she had trusted him, that I had to understand how hard this was for her. There was truth in some of that, probably, but she had sat in my living room on the day of her son's funeral and called me inexperienced and vulnerable, and helped build the framework that Barrett was planning to execute against me. The complexity of her guilt was not my responsibility to manage. I did not call her back. Barrett was charged with estate fraud, forgery, and attempted financial elder abuse. The last charge because one of his previous fraudulent debt claims had targeted an estate where the surviving spouse was over 65. His real estate projects collapsed entirely when his lenders pulled their positions following the indictment. The development company he had been running for 11 years dissolved within 2 months. He lost the legal right to serve as an executor or trustee in the state of Tennessee. My father-in-law did not speak publicly. I heard through a cousin of Conrad's who still occasionally texted me that he had taken it hard, that there had been a significant falling out between him and Barrett, that the family Thanksgiving that year had not happened. I did not ask for details. I finished out that year working from home, managing the estate transition, sitting with grief in the quiet of a house that still smelled faintly like the cedar soap Conrad had used, finding his handwriting on the back of grocery lists tucked into kitchen drawers and holding them for a long time before putting them back. The following spring, I officially assumed management of the trust and began working with the logistics company's board to understand my position as a significant stakeholder. They were surprised to find Conrad's wife at the table. Then they were not surprised because Conrad had apparently told his business partners quite a lot about me. I moved into a smaller apartment on the east side of Nashville, close to a park where I run in the mornings. It is quiet in a way that I had to learn to inhabit. Grief is not linear and it is not a problem to be solved, and I want to say that clearly, because some of what I have described might make it sound like the legal and financial victory was the story. It was not. The story is that I lost someone I loved deeply, and that his love for me was so thorough, so carefully constructed that it protected me even after he was gone. That is the part I return to when the nights are long. I kept the casserole dish my mother-in-law left. I use it to make the roasted chicken recipe that Conrad taught me. It is a good dish. There is a particular kind of strength that does not announce itself. It does not perform. It does not react. It waits, and it builds, and it uses what it knows. Conrad built that kind of strength into the architecture of everything he made. I have tried to build it into myself. If someone in your life is betting on your grief, making you easy to take advantage of, they are making a very expensive miscalculation. You do not have to be loud. You do not have to be angry. You just have to know what you have and hold it and wait for them to show you exactly who they are. They always do. If any part of this story is living in your life right now, or if you have had to navigate the particular cruelty of people who use loss as an opening, I want to hear from you in the comments. Share what happened. Share what you did. This channel exists for exactly that. And if this story meant something to you, please subscribe. There are more stories coming, and every one of them is about people who decided not to stay down. I have thought a lot about what made Barrett so certain he would win. He is not a stupid man. He built a real company, ran real projects, managed real money for over a decade. But somewhere along the way he started to confuse the appearance of confidence with actual competence, and he started to believe that grief was a kind of stupidity. That a woman standing at a graveside crying was a woman who could not think. That loss made people soft enough to sign things without reading them. What he did not account for was that Conrad had spent 4 years watching me work. He had sat across from me at the kitchen table on late nights while I pulled apart financial records, looking for the single transaction that did not belong. He had listened to me describe how fraud actually operates, not the dramatic version from movies, but the real version, which is usually quiet and paperwork heavy, and depends entirely on the target believing that the person presenting the document has their best interest at heart. Conrad paid attention. And then quietly, without telling me why, he built protections around our life that assumed the worst about the people who might one day try to take advantage of me. That is the part I keep returning to, not the legal victory, not the moment Barrett's company dissolved or the moment his charges were filed. What I return to is the understanding that Conrad's love was not passive, it was active and structural and forward-looking. He loved me in a way that had contingency plans. There is a version of this story where I do not know what I know. Where I am just a grieving 31-year-old who signs what people put in front of her because they are family, and family does not do things like this. I have met that woman in the case files I used to build for litigation. I have read her deposition transcripts. She is not naive. She is just alone in a moment that is designed to make her feel like fighting back is the cruel option. What I want to say to her, and to anyone sitting in a version of that moment right now, is that knowing your own value is not arrogance. It is protection. The people who came into my home the evening of Conrad's funeral were not powerful. They were desperate, and they had built their entire strategy on the assumption that I would not look closely. The moment I looked closely, the whole structure collapsed under its own weight. Barrett's ego did the rest. He walked into my kitchen and confessed to fraud on a running recording because he genuinely believed I was too broken to be paying attention. Being underestimated is not a disadvantage if you know it is happening. The ethical failure at the center of what Barrett did was not just legal. It was a decision to treat another person's worst moment as a resource. That kind of thinking does not start the night of a funeral. It builds over years of small compromises, small rationalizations, small moments of choosing convenience over integrity. By the time Barrett sat across from me with that forged document, he had already made 1,000 quieter decisions that led him there. The consequences were not sudden, they were accumulated. I'm not glad it happened. I would trade every dollar of that estate to have Conrad back. And I say that without hesitation or performance. But I am not ashamed of how I responded. I used what I had. I stayed calm when calm was the hardest thing to be. I let people show me who they were, and then I acted on what they showed me. That is not revenge. That is just paying attention. If you have ever had to protect yourself from the people who were supposed to protect you, you already know that the strength required for that is a very specific kind. It does not look like strength from the outside. It looks like stillness. It looks like patience. It looks like a woman sitting on her couch drinking tea. She is not drinking, nodding at the right moments, and waiting. Subscribe if this story found you at the right time. Leave a comment if you have lived something like it. I read everyone.